Hello, my name is Van Smith, managing partner here at Smith Strong, and today I'd like to talk to you about an interesting case that underscores the need for trial skills for your divorce hearing. In this case, Fairfax v. Fairfax, on appeal that was decided in April of 2025, the Virginia court upheld that a Stafford County divorce decree that relied on the wife's therapist who testified to the ongoing stress, abuse, and physical harm the wife had suffered allegedly in that divorce. And the court relied on that expert testimony of that therapist from the hearing that was heard on testimony after being sworn in as a basis for establishing a divorce on the ground of cruelty, which of course then meant an award of spousal support, in this case, $2,000 in spousal support for 15 years, among other awards. And so on appeal, the husband appealed that and said it was unfair for the court to rely on that expert and that testimony as a basis for establishing a grounds of cruelty and giving such an award to the spouse in that case. And the court said, look, trial skills 101. If there is an expert and you're objecting to the testimony of that expert objection must be made at the hearing at the time of the testimony. In this case, as the Court of Appeals laid out in the fact pattern, the objection the husband raised was not made until the decree was entered long after the hearing and the testimony had been given. And so the Court of Appeals found that objection was too late. And so this underscores the need to really, when you're selecting counsel, not that I'm speaking about any individual counsel in this case, I don't know who they were, but when you're selecting counsel, it's very important to make sure that they are in court on a reasonable basis, at least monthly, probably weekly or every other week, to ensure they have the trial skills necessary if your case goes to court. About 19 or 20%, thankfully, of our cases, not more, go to court. That's 1 in 5. The other 4 and 5 settle. But for those 1 in 5, that day is a very important day. And so you need skilled counsel to know when objections need to be raised, to understand the exhibits and the summaries of the case and have questions laid out and have your objection strategy ready well in advance. And oftentimes I have found as I reflect on the thousands of cases we've had here at Smith Strong in divorce and custody context, that oftentimes cases are, not always, but cases are often won or lost with the binders brought into the courtroom before the hearing ever actually begins. And it's that age-old lesson, preparation wins the day. And so it really requires in these case preparation meetings for a detailed exec summary to be constantly refining, an exhibit list to be constantly agreed on and refined, the questions for all witnesses, including the opposing parties' witnesses, needs to be understood and a strategy developed. The likely objections need to be thought of in advance. All of this requires skill and time. And here's the good news. This preparation usually helps get a case settled. The more a case is prepared and examined, the more likely it actually is to settle. I have found that a lot of the cases that have gone to hearings is oftentimes due to the disorganization of the other side in really understanding what the case was about and the facts and the assets and the debts. And so they go to court simply because they ran out of time in trying to prepare it properly, to understand how to settle it. And so they said, we'll just put the evidence before the judge and let the court decide. Terrible way to practice law. And so in preparing these cases right, you're incentivizing yourself to understand and get a case settled. But then for the 1 in 5 that don't, you're confident walking into that courtroom. And that's what you see on the reviews at Smith Strong is the confidence in the preparation. And that lends itself to outcomes beyond even the skill of any individual attorney, simply being so prepared that they do better than they should. Thank you for the time, and I look forward to working with you. Message or give us a call And don't forget, I've written a book, The Ultimate Guide to Divorce and Custody in Virginia. It's available for free on our website. Simply download that. You can read it on your smartphone. We'll even mail you a hard copy if you'd prefer that. So just let us know how we can assist you, and we will empower you with education that will guide you through the entire cycle of your divorce or custody case at our firm. Thank you.